Good afternoon, everyone. My name is Peter Rothberg, and I'm a partner at the Reitler law firm based in New York City. We are a boutique law firm that specializes in dealing with the issues that young startup companies and venture funds have. That's the, I use the phrase, sweet spot for our firm. And my practice falls straight in the heart of that kind of practice. I represent young companies, I represent older companies, I represent companies taking themselves all the way through their life cycle from pre-incorporation or pre-formation, all the way to hopefully a very favorable exit. I also represent venture funds and angel networks, as well as other things like wineries and bakeries, multi-city bakeries, and a whole host of things. So that's my practice. Today, we're going to talk about the early legal issues for startups. This is something that I've been talking about and practicing for a number of years, and I hope that the information that I can provide to you today will be helpful. So next slide, please. Okay, so this is always a very interesting topic. What are the legal agreements that founders should have in place when they're forming their ventures? And I think there's a lot of agreement within practitioners about this. Something that I think is very helpful, and I've seen this be very, very helpful in actual practice. One of the things that I do is I'm the lawyer in residence at the NYU Business School Entrepreneurship Program. And what that means, very simply, is that one of the things that I do is I run a legal help desk. And I run a legal help desk for team members in the NYU Business Plan competition, which they have every year, as well as for NYU alumni and faculty members and other things. But what I do see when I'm representing or when I'm advising the teams in the business plan competition is that they really have a lot of trouble, as I'm sure many of you have, in figuring out what should the relationships be among the founding team members. And one of the things that can really help in drawing people's attention so that they can focus on the issues of forming a venture is to have a non-binding memorandum of understanding among the founders, in which before you get to a lawyer, before you go too far down the line, you may think that you and your roommate or you and your old friend are in alignment because you're just talking about things. But when you actually have to put things down on paper, even in a non-binding way, it really draws everybody's attention to what's really going on here. So a pre-incorporation memorandum of understanding that talks about what are the equity splits among the founding group. Who's going to actually be the CEO of the founding group? What are the other duties that the founding members are going to have in this company? And are we going to have what I call a repurchase agreement, a vesting schedule on everybody's equity in the founding team? These are things that can really be drawn out and can really rise to a level of consideration that is very important, I think, because if you are not really in alignment on these other important things that I just mentioned with your other team members, you're not going to have a very successful team. And it's better to find this out sooner instead of later. So I'm a big fan of a memorandum of understanding among the co-founders. And what that can also do is when you have already hashed out among yourselves the terms of a memorandum of understanding, then when you go and see a lawyer to begin to actually create the company and build the legal foundation for the company, you've got a real head start. You've saved yourself a lot of money in dealing with, and time in dealing with that law firm, because you've already hashed out a bunch of thorny issues. You don't need your lawyer to help you hash those out. Now, I've hashed these out in my practice many, many times, and that's why I've seen how having a memorandum of understanding up front can really be beneficial to a co-founding group. The other organization agreements that I think all practitioners would agree are essential are a founders agreement, a stockholder agreement, a limited liability company operating agreement, a repurchase agreement, and potentially a buyout arrangement. So let's talk about these. What a founders agreement does is I call them a stockholder agreement light, because whereas a stockholder agreement and a limited liability company operating agreement, the stockholder agreement for a corporation takes the same place as a limited liability company operating agreement for a limited liability company. They are very much the same. They lay out all of the ways that the stockholders or members respectively are going to deal with each other and what's going to happen with the equity that people own in each of these entities. So when I talk about how they're going to deal with each other, that is, a stockholder agreement or a limited liability company operating agreement will lay out who are the board members, which means who manages this entity, who's the CEO, who are the board members, if there are going to be any protections for minority members, right? So sometimes you don't want everything to go by majority rule. There might be, depending upon the situation, there could be times when, although the majority can get their, the majority of the members can get their way in most things, but sometimes you're going to want some very important decisions to not necessarily be made only by the majority. So I call these protective provisions, which says that if we're going to make a decision, let's say to sell the company, then you need more than just a majority vote of the stockholders to do that. You might need a supermajority or a 2/3 vote of the stockholders. And that allows people that might have 40%, collectively a 40% interest in the company, to not get railroaded by the majority holder, to have everything done that the majority holder wants. So those are what I call protective provisions, and you'd find those in a stockholder agreement or a limited liability company agreement. What a founders agreement is, when I say it's a stockholder agreement light, is that the founders agreement typically will only deal with what happens with people's equity in that company. So let's say you have 4 founders and everybody has a 25%. So you have 4 founders and they're equally divided in their equity, 25% for each. So, whether or not you need protective provisions in that arrangement is a question that we could go through at another time. But certainly, even if you don't need the protective provisions here, because the only way to get above a majority is you'd have 3 out of the 4 people would have to agree to take a lot of actions, and therefore the 25% minority interest might not need or might not be entitled to protective provisions. But you certainly want to make certain that any one of the founders can't just transfer their equity without any restriction. So the founders agreement will typically deal just with those equity transfer types of issues. So what do I mean by that? One very typical thing that a founders agreement has is what we call a right of first refusal. And what that means is that if I am a founder and I want to transfer my stock to a third party outside of the group of founders, then the members of the founder group and the company, typically it's the company first and then the individual founders, have the right to purchase the equity that is proposed to be transferred. Before it can be transferred to the other party, they have the right to meet the price and the terms that this third party is offering for the founder's equity. You can see how that would be a very powerful tool. You're a 3 or 4 person founder group. You don't necessarily want someone that you don't know to become a part of your founder group now, to have 25% of the equity of your company when there's only a few holders of all of it. You want to have some control over who's going to be brought into your group. So who's going to be able to buy that equity? So a ROFR, what we call a ROFR, a right of first refusal, is a very important tool. By the same token, we also have what let's call a tag along. provision. And a tag-along provision says that, okay, one of us went out, one of us wanted to leave the company or sell some, we wanted to lighten their equity load, the amount of equity in the entity that they had. They want some liquidity. So one of our co-founding group went out, found a buyer, and that buyer said, I'll buy your stock for $10 a share. Well, the other founders looking around and going, $10 a share? I didn't think our equity was that valuable. So I may not want to buy using the right of first refusal. I may not want to pay $10 a share for the equity in our company. But boy, I'd certainly like to sell some of mine at $10 a share. So the tag along will allow you, if you haven't exercised your right of first refusal, to be able to tag along on that sale to the third party. Now that will reduce the amount of shares that the initiating founder can sell now, because the buyer is not necessarily going to want to buy all of the stock in this entity. So they've said they only wanted to buy 25%. Now that 25% can be split among the founding group so that everybody can get a little liquidity at that price. So that's the tag along provision. Another provision, which is also very important, is a drag along, which you can probably intuit what a drag along is. What this says is that, and here's where you can get into, very typically it's a drag along is triggered by a vote of the majority of the equity holders, but it can also be triggered by a supermajority. So you could say, no, the drag can only be triggered if 2/3 of the equity holders want to do this thing. And what this thing is typically a sale of the company. So that if, let's say it's a supermajority, if 2/3 of the shareholders find a buyer for the whole company, and that buyer only wants to buy the entire company, everybody's stock in the company. They don't want to have any minority shareholders after their transaction. Then the 2/3 are able, if this is what's in your agreement, they can trigger the drag along and drag all of the shareholders into the sale transaction, so that there is not an intransigent minority shareholder left over who could block the will of the majority, or in this case, a supermajority when it comes to selling the company. So the drag along is also a very powerful tool, and in a founder's agreement. The piece that is typically in a founder's agreement, and that you'll also find in stockholder agreements, and many times this agreement it can be separate. Any of these things that I'm talking about can either be combined into a single agreement, or they can be found in separate agreements, almost like modules to a founder's agreement. You could have a simple founder's agreement with an Exhibit A, and Exhibit B, and Exhibit C, and each one of these will have one of these separate pieces that I'm talking about to be attached. And the repurchase agreement is very frequently an attachment to a founder's agreement or to a stockholder agreement. And what this says, and this is very powerful, is it says that all members of the founder group, in order to hold on to all of the equity have been granted in this company, you must continue to provide full service to the company for a period of years. So typically what I see is a 3-year repurchase agreement, what we'll call a vesting clock. So the typical vesting is, if you have a 3-year vesting clock, you will vest in your equity monthly over a 3-year period. So that if you leave the company before the end of the 3 years, the company has the right to buy back the shares that have not vested. Meaning if you leave after year 1, then year 2 and year 3's worth of vesting, the company can repurchase from you for what you paid for it, which is typically nothing, or very modest nominal amount. And that way, this is sort of like golden handcuffs, that it keeps the team together, which is really important, because you don't want people leaving the team before the company is really built. And certainly investors in the company are not going to want the team to get broken up before the company has achieved some of the milestones that they attracted the investors based upon. But even, I don't know, even more importantly, but of equal importance is the fact that you don't want, with a young company, typically the founders are all there because each one is providing a particular function. And in order for the company to really be successful, all of these 3 or 4 functions of the founding team need to be pulling in harness together over this vesting period, this 3-year period. If one of the co-founding team's members leaves before the end of this period, well, the company is going to have to replace that person. And they're going to have to typically, because these companies don't have a lot of cash, your real currency is equity in the company. So you're going to have to offer a similar amount of equity to the new person who's going to be performing the function that the leaving founder performed. So what that means is that if you don't have a repurchase agreement with respect to each one of the founders, that founder can leave with all of that founder's equity. And then when you have to replace that founder with a new person for performing the same function, and you're going to have to give that person a similar amount of equity, then all of the other members of the company are diluted by this replacement of the founder. And the founder who leaves could leave with everything. They might have only worked for, an extreme example, so they worked for a month after the equity is issued to them, and they leave after a month, and they can leave with all of their equity. You wouldn't think that's very fair. And I don't think anybody would think that that's very fair. So the repurchase agreement is not only a golden handcuffs to keep people together because they're going to want to vest in all of their equity, but it also provides a mechanism to prevent undue dilution to the remaining founders when you have to replace the founder who left. Now, the last thing that we can talk about, and this, I don't see this that frequently, but it does occur, and it is something that people think about and they put into their organizational agreements, and that's a buyout arrangement if there's a founder breakup. So we've talked about founder breakups a little bit in the repurchase agreement discussion. The buyout arrangement comes in very typically if you have 2 founders, so it's a 50-50 arrangement, and there's a potential for deadlock in that kind of an arrangement. And I've drafted these provisions before, mainly when it's a 50-50 situation. So what these buyout arrangements do is they provide for a remedy if there is a deadlock. If the 2 partners, the 2 founders cannot agree on major decisions, and one of them says, this is intolerable, we need to break up over this. And what the breakup usually has is a buyout arrangement. So if I'm triggering this deadlock, then there's a mechanism for how the equity of either the person triggering the deadlock gets to buy the other's stock, or the person who didn't trigger the deadlock gets to buy the triggering equity holder's stock. There's all kinds of different ways that this can be worked out, but you can build that in. And it's especially powerful if it's a 50-50 arrangement. But in the absence of that kind of an arrangement, what really happens in a breakup when a founder's leaving is that either the repurchase agreement kicks in if it's early enough, if it's within the 3 years after all these agreements are first put into place, then you exercise the repurchase and the shares go back, the unvested shares go back into the company. Whatever shares that vested in the hands of the leaving founder are then they're still subject to the right of first refusal. So if that founder ever tries to sell them later on, you can always get them back by using the right of first refusal. In addition, in my experience, when a founder leaves, you're not only relying on the right of first refusal to deal with that person's equity. There's typically a separation agreement that has a bunch of other things in it. I mean, usually there's going to be at least some kind of a transition period for the leaving founder to continue to provide some service to the companies to ease a transition to a new person performing that founder's function. So a separation agreement is typically going to come into play when there's a founder breakup. So there really isn't a lot that you can provide for at the initial juncture, unless you've got a 50-50 situation and you do want a buyout arrangement. You'll usually rely on the repurchase agreement, on the ROFR, and the fact that you're going to negotiate something later on. I think that's really how these things work out. The other thing that is key is dealing with equity in incentives. And so I think it's very important to create an equity incentive plan very early on so that you have a mechanism for bringing in new people into the founding group. Because of course, once you get started, the value of the equity will hopefully increase. And then it gets to a point, to a value that makes it very difficult for new people coming in to be able to purchase the equity from the company. So you want to set up particular mechanisms in your organizational agreements that can deal with new employees, new consultants, obtaining equity in the company in lieu of getting cash compensation, or in lieu of part of the cash compensation that they might otherwise be entitled to if they were working for a more seasoned company. And you want to try to get this equity to them without it costing them anything, because that's just what people want. So if you are dealing with equity incentives, and these are all kinds of different equity incentives that can be created. We're talking about very rudimentary ones at this juncture now in this discussion. But the two simplest things that you could do is, if you have a limited liability company, you will then create what we call the ability for profits interests. And profit interests are equity interests in the limited liability company that, when they are granted to somebody who is performing services for the company, that when you grant them to that person, there's no tax on that grant. So the IRS deems that a profit interest that's properly granted to have no value at the time that it is granted. So that person receiving it is not receiving any compensation on which they have to pay tax. And they will then grow in value as a company grows in value, because they function just like equity. But the difference is, the reason why they have no value is that the person that gets a profit interest does not get any of the value that has been built up into the company before the time that the profit interest is granted. So if we call that a hurdle, a threshold value. So if, let's say, the founders have been working on the company for a year, they built up the value of the company to have a $1 million value, and now they want to grant profit interests. Well, the threshold, below which the profit interest holder will not get any return on their equity in a liquidity event, would be that $1 million. So the profit interest holder would only be able to benefit for the run-up in value in the company beyond that initial $1 million. So that's the profit interest, and those are only available to limited liability companies. What you do with a corporation is you'll set up a stock incentive plan, and that will mainly deal with options grants to employees or to consultants. And that allows people to receive an option with an exercise price to acquire the stock by exercising the option at a price that is equal to the fair market value of the stock on the date of the option grant. So again, the IRS says, if I give you an option under one of these plans and the option's exercise price is equal to the value of that stock on the date of grant, there's no tax to you, and you're not going to get taxed on this instrument until, depending upon the kind of option, either when you exercise the option later on. If it's a non-qualified option, you'll get taxed on exercise at the difference between the exercise price and the fair market value of the stock on the date you exercise the option. And if it's an incentive option, if you're able to get an incentive stock option because you're an employee, then you're not even taxed when you exercise. So you're not taxed on the difference between the exercise price and the fair market value of the stock at the time you exercise the option. You'd only be taxed when you sell the stock that you acquired on exercise of the option. So that deferral of paying the tax on the value of what you get is a very nice feature of incentive stock options, but they're only available to employees of the company that issues the option. Next slide, please. So here are a few things that you should not do before you've organized your entity. And what I mean by organizing your entity is that we have in this country, as in most countries now, but you'd be amazed that these did not really exist before the 18th century. Limited liability entities. A corporation is a limited liability entity. A limited liability company is a limited liability entity. And what that means, if you create a limited liability entity and you are conducting your business through that limited liability entity, then you, as the equity holder of the entity, are not liable for the debts or the obligations of that entity. You're not individually liable anymore because all that liability rests with the limited liability entity, so that anybody that is doing business with the entity is not doing business with you anymore as an individual. They're doing business with the entity, and they will have to look to the entity for any compensation, from damage that the limited liability entity might have done to them. It's a very powerful tool. So I always advise clients, do not conduct your business other than through a limited liability entity. And by conducting business, I mean, don't accept funding from friends and family, angels, or institutional investors before you've created this limited liability entity. Let that entity be the funding vehicle. Don't commit to any binding agreements or provide service or do anything, even a beta, even operating your site in beta. I would not do that unless you have a limited liability entity that is available. And most importantly, don't make any binding commitments for equity grants to any person, whether for cash or other services, before you have a limited liability entity. We live in a very, very litigious society. People can sue you for anything. And even if they don't win, if you can be sued, it's very costly, it's very time consuming, it's frustrating, it's depressing. So it's one thing if someone is going to sue the limited liability entity. That's bad, right? If you're a founder of the limited liability entity and someone is suing the entity, I mean, that feels terrible too. You're still going to have to take a lot of your time to defend the entity, but you can take the comfort that you're not going to lose any money other than the amount of money that you've already invested in the entity. I mean, the entity could go down the tubes, right? This litigation, these claims that could be made by people that dealt with with your limited liability entity could be crushing and could put the company out of business. But you, as the individual, all that you can lose is what you've already. I mean, you lose, the time that you devoted and all that. But they can't. But the plaintiff can't reach through the entity and grab your individual resources, right? They can't make you bankrupt and take everything that you have because of something that the entity did. And that's the difference. And if you're acting other than through a limited liability entity. I think we addressed this in the next slide. Next slide, please. When should you incorporate? I think we just talked about that. Prior to commercial activities, prior to taking money into the company for the sale of equity, I think we alluded to some of the different forms of organization that you can use. The sole proprietorship or a general partnership are those kinds of arrangements that I think should not be used when you're running a business, because then with a general partnership or a sole proprietorship, everything that you, the individual person, that is operating this business, all of your assets are on the line and available to your creditors. So do not use those kinds of organizations for running a business. The things that are most useful are the C corporation, which is, they call it a C corporation, but it's what you would normally think as a regular corporation with limited liability, or a limited liability company, which again provides the members with limited liability. People do sometimes still deal with an S corporation as the format, but I think in most cases, the limited liability company has taken over as the entity of choice from S corporations when you want the following from the entity that you're going to use. You want limited liability, but you also want the ability to pass through. You want this entity to be a pass-through vehicle, which means the entity itself is not taxed, but any losses or profit that are generated by the entity pass through directly to its members. So it's more tax efficient, and it especially is very helpful when the limited liability entity is throwing off a lot of losses, as they all do in the beginning. And then the members can use some of those losses to offset their own taxes in their individual tax accounts. And a lot of people like that. It can be very beneficial, but it would be a whole other discussion and session, which maybe we can have another one to talk about this, as to when to use a limited liability company or S corporation and when to use a C corporation. There are all kinds of practical reasons to use one or the other, but I think that discussion goes beyond the scope here. And lastly, where to incorporate or form. I always recommend Delaware. I mean, I love New York State, born and raised here, live here still, practice law here. But the Delaware Corporation Statute is really more management friendly than the New York statute. It has a huge amount of case law that interprets it. I mean, New York does too, but the Delaware statute is interpreted, very, very broadly. You can very easily find an answer to almost any question that you have about the Delaware statute. And the other thing is that New York law is known by people in New York State. Now, that we have a huge bar here, so that's a very good thing. But Delaware law is known by any decent corporate lawyer throughout the entire country. So it makes it easy. If you've used Delaware law as your incorporation or your formation statute, then the lawyers for your investors, who could come from anywhere in the country, will be familiar with Delaware law. They'll be familiar with your organizational document, and it will be easier for you to deal with those investors and their counsel if you're already a Delaware corporation. And also, the dirty little secret is that in almost all deals that I do with venture funds, even with a ton of angel networks now, as a condition to their investing money in your company, they will require you to reincorporate in Delaware. So you'll have to deal with this later on anyway. It doesn't cost you that much more to be a Delaware than a New York corporation. All you have to do is you would incorporate in Delaware, and then if you're operating your business in New York, you would have to qualify to do business in New York, pay New York a little fee to do that. If you're in New York, you're going to be paying your income taxes in New York anyway. You don't pay income taxes in Delaware, but what you would pay on a yearly basis is what we call a franchise tax, which is a tax you pay to Delaware for the privilege of being a Delaware entity. And in the early years, it's not a big number. So I always recommend that people just go and incorporate in Delaware right off the bat if your plan is to take in investor money. I would always recommend Delaware. If you're not going to seek outside financing at any time in the future, you're sure of that, New York would be a fine choice. But I still think Delaware is a more flexible statute. Next slide, please. Okay. Now, intellectual property. This is a very, very interesting topic for young companies, and it's something that people that don't practice law don't always realize. People think that if I'm working for the company, if I'm an employee or if I'm a consultant and the company has hired, and if part of my duties as an employee is to develop intellectual property, and part of my duties as an outside consultant is to create intellectual property, that simply by my being paid my salary or my being paid my consulting fee, that everything that I develop during the course of my work belongs to the company who paid me. And the answer is that is not the case. If you're an employee, then the doctrine of master-servant comes into play, and an employee will automatically have assigned to its employer most of what that employee is going to be developing in terms of IP during the course of employment. But there are limits to the master-servant doctrine, so that if I'm working outside of the 9 to 5 time frame, if that's my normal time of working, and I bring my laptop home with me, my work laptop, and I'm working at midnight on something that is outside of the scope of what I was doing for the company, then the master-servant doctrine might not grab that IP, right? That IP, even if it's maybe in a related field to what I did, but not exactly what I was doing for the company might not own that. And certainly if I am a consultant, unless I have a written agreement with the person who's paying me for my work, that whatever I develop is owned by the person who paid me, if that is not there, I haven't transferred that IP to the person who paid me. I have to officially, in a formal agreement, transfer that IP that I've developed to the company that paid me for the development of it. There are some exceptions to it, but no one with their right mind ever just relies on the letter of the law to cause a transfer of this IP back to the company. We always create an agreement. We always create language in a consulting agreement that deals with the transfer of ownership of the intellectual property that was created pursuant to the services provided under that consulting agreement. So that's really important. That all comes in to, on the slide, the proprietary rights invention assignment agreement. That is something that I usually will create a module for this. One is for consultants, one is for employees, and I just attach that as an exhibit to any consulting agreement that I'm working on to make certain that the inventions developed by the consultant go back to the company that paid them. And every employee with every company that I represent, we always advise them that they should have a separate proprietary rights invention assignment agreement to be signed by all employees on the date they become employed. On that day that you shake hands and go, welcome, whatever they're signing to become, whatever that signing package is. Maybe there's an offer letter, maybe there's some kind of an IRS form. Now you know that you have to have immigration forms signed. All of that at the same time that they sign on, you're going to have them sign a proprietary rights agreement too. Many companies build the invention assignment proprietary rights language into their handbooks, but I think it is better in my practice, because a lot of young companies don't have employee handbooks. They don't get employee handbooks for some time later because they're not necessarily that inexpensive to create if they're going to be created properly. So I always rely on a proprietary rights agreement to be signed by employees right at the beginning of their employment relationship. So I think, in a pre-organization format, what you also should be doing is, a lot of times when you have a co-founding group, the co-founders are transferring to the company some IP that they have previously created, which is the foundation of the company. So that goes back to what I said earlier, that people think, oh, I am a co-founder and I've been working on this for the entity, so the entity must own it. No, the co-founders have to make formal assignments to the entity when it is created of the IP that they've developed pre-organization that relates to the business of the company that they just formed. So you have, it's not a very complicated document, but you must have this assignment from the founders to the entity in order for the entity to have ownership of the IP. Part of any proprietary rights agreement is also a non-disclosure agreement. This is going to be part of it. And that means that we're going to define what confidential information is. We're going to say that the company owns all of its own confidential information, and you, either an employee or a consultant, are not permitted to disclose to anybody, subject to some exceptions, which we don't need to talk about now, but subject to very specific and limited exceptions. The person that has come into contact with the employers or the hirers' confidential information, that person cannot disclose that confidential information to anybody. They can only use that confidential information in connection with their work on behalf of the owner of the confidential information, which is the company. Next slide, please. So I think we've talked about some of these agreements. And so one of the things that you're going to want to do when you begin to employ people is have an employment offer letter or an employment agreement. Usually you don't have employment agreements apart from the, oh, here comes my kitty, apart from people in the C-suite, the CEO, the chief marketing officer, those type of people are not typically going to have employment agreements. It's not needed, because what you really deal with in an employment agreement is you're really dealing with severance and heavy duty benefits and equity grants. That's what you're usually going to get with an employment agreement, grounds for termination, that kind of thing. With lower level employees, really all that you want to do in an employment offer letter is you want to identify what their duties are. You want to definitely have an invention assignment piece, as we talked about, that's really, and you're going to specify what their salary is. You're going to specify that they're employees at will. They could be fired at any time by the company, and you're not going to provide for severance. You're not going to provide here for equity grants. So sometimes you do. Sometimes even for a lower level employee, the equity grant, the option grant is something that is very important to this person, and it justifies their taking the job with you for less than what they might otherwise make. But you don't really need an employment agreement until you've reached the upper echelons of a company. A key agreement, if you're going to have a consultant or an independent contractor, is again, the consulting agreement is going to provide for the duties of that, what the services are of the consultant. It's going to provide for the ownership of IP, things that we've talked about previously, the transfer of that ownership. And here's where you might get into a couple of additional things. There's definitely going to be, as a part of any employment offer letter, a part of any independent contractor agreement, the confidentiality provisions that we talked about earlier. But here's where you might also want to add a few other things, such as non-competition and non-solicitation. It's becoming increasingly difficult to enforce non-competition agreements at the lower echelon level. Courts do not favor non-competition agreements. They view these as a restraint of trade. And in order for you to be able to impose a non-competition agreement, you really have to have a reason. So if someone is a lower level, non-supervisory or even supervisory at a lower level employee, the company doesn't really need a non-competition, and it might make it more difficult for the employee to get employment elsewhere. So courts will strike those down very frequently. And in some states, Massachusetts and California, well, in California, non-competition agreements for employees are not enforceable, period, end of story. Massachusetts has imposed by statute a lot of heavy restrictions on the enforceability of non-competition agreements. And New York State is when these non-competition agreements end up in court, they're also being scrutinized much more by courts these days. So you have to be very, very careful. And certainly courts in New York, from what I'm told by my partners in our labor group, are not enforcing non-competition agreements for employees if they go beyond 1 year. And what they used to do in the New York State courts is they used to say, well, you gave us a 2-year non-competition. We're going to rewrite it for you so that it is now at an enforceable level. So we're going to rewrite it from 2, which is not enforceable, to 1, which is enforceable, and we're going to enforce the 1-year non-competition period. What I'm told now a lot of courts in New York are doing is they're going, you know what, plaintiff, I'm not your lawyer. I am not going to rewrite this agreement for you so that it is enforceable. If I find your agreement to be non-enforceable, it's not enforceable, and I'm not going to lower the non-competition period so that it is an enforceable length. So that's happening in New York courts now. So you have to be very, very careful with non-competition agreements for employees, and you really consider whether you need it at that level of employee. What a lot of people will do, and this courts are fine with, is a non-solicitation. So you can have, in your agreements with your employees and with your independent contractors, a non-solicitation agreement section. And what that means is that you are not, after our agreement ends, after your employment ceases, or after our consulting agreement terminates, you are not going to go and try to hire people that you met at my company that are working for me. That is interfering with my business, and you're going to agree, typically for a 1-year period, not to come in and solicit my people to leave, or solicit my customers, or solicit my vendors, people who sell me things, to interfere with my business with those people. I mean, you're not going to do things like, you're not going to take one of my customers, which in a way will lessen their doing business with me, because now if they can buy the same thing from you that they used to buy from me, they're not going to buy it from me. And I don't want you to do that for the 1-year period. And those kind of agreements are enforceable. So non-solicitation agreements are enforceable. Non-competition agreements are more controversial today. Next slide, please. Early financing issues. This is a topic all to itself. There are many, many ways that you can finance your company. A lot of young companies start off with friends and family. Go to Uncle Ned and Aunt Bertha and say, hey, I'm your favorite nephew, and I want to start this company. Can you help me? That's how you can start. Then after friends and family, you can go to seed funds and individual angels, as well as venture funding. So there's a progression. You don't typically go straight to venture funds, because venture funds nowadays are pretty particular as to what they're going to finance. They have all kinds of rules and all kinds of, not necessarily rules, but expectations about companies that they're going to finance. And it would be very difficult for them at the very earliest stages, unless you were Steve Jobs coming to them with a new venture at which they would jump. But if you're just a regular old person, going right to venture fund before you have proved proved your concept, or had any revenue traction, or had any users, or anything like that, would not be would be a very unsuccessful effort. And that's the same with seed and angels nowadays. You really need to show them some level of success, some level of adoption of the services or products that you are providing, in order for you to get any kind of financing from those types of financial partners. But friends and family, that's where you go first to get yourself off the ground and begin to show that there's something here that is worth investing in. The vehicles that you can use are really the same that you can use at any of these levels. Promissory notes, We know what that is. It's your agreement that you give me $100,000 and I agree I'm going to pay you back that $100,000 under certain terms at a certain interest rate, pay over a certain period of time until maturity. A typical promissory note will not have an equity component to it. A convertible note or a SAFE or a KISS, these other kinds of convertible vehicles that are out there now, will say that, yes, I mean, if it's a convertible note, yes, you're going to give me money, and yes, there's going to be a maturity date, and yes, there's going to be an interest rate, but we're going to specify in this security how it can be converted into equity of the company. Under what circumstances will it be convertible, and at what rates, meaning dollars of debt to equity, what are those rates of conversion going to be? The difference between a convertible note and a SAFE is that a SAFE is not a debt instrument. It is deemed by tax lawyers to be an equity instrument, and it is simply an obligation that when you invest in my company and I issue you a SAFE, I'm telling you that I am obligated to convert this SAFE into another form of equity of my company under certain circumstances. A SAFE does not have an interest rate, so interest is not accruing, so it's not as desirable to investors as SAFEs are. SAFEs are more desirable for companies, but SAFEs are now beginning to get not as complicated as convertible notes, but they're getting there. There are all kinds of different terms attached to them now, and a SAFE is, a SAFE was developed by a group out in California. The name is escaping me right now. It's a very, very big venture group, and they were supposed to be simple, but as they've been used over the years, complexity is being engrafted onto them. So they're not really as simple as they used to be, despite the fact that they're simple agreements for equity. But either one of those vehicles can be used. And then you can have a direct equity investment. But the problem with a direct equity investment for a young company is that a direct equity investment has to decide upon a value for the company, right? And a value for the company now. We have to agree that my company is worth $1 million, and if you're going to give me $100,000, that means you're going to get 10% of my company, and we are agreeing that that's what everything is worth. It's very difficult in the early stages of a young company to come up with that value. I mean, you might be at a time when you've got this great business idea, and the business idea has a huge market for it, so the company could become a rocket ship in terms of value if the founding team can really execute on that business plan. But it's really so early that who knows what the company is worth. The company could be worth nothing right now. So it's difficult for a young company to take direct priced equity into its company. And that's why at the earliest stages, the convertible note, the SAFE, the promissory note, which you hope will later be converted on terms that you don't want to agree to now, those are better to be used for young companies because you're not necessarily giving away too much equity, because the company at its current value, because you can't value it, you might go too low, and therefore you give your investors too good of a deal. And the investor on the same side, at the opposite side of that equation is saying, well, how do I know what this thing is worth? This thing could totally crap out, and I could be valuing it as though it's worth $1 million and it's really worth $100,000, and I'm really paying too much for what I'm actually getting. So to cut through all of those different scenarios, for the earliest stages, I think convertible notes or SAFEs are a better bet for the young company, because I think it's too difficult to really come up with a direct equity value for the company at that point. What are some of the key things that you should look for when you're negotiating an investment? I think it goes back to, whenever you take in investment from a third party, then you're going to want, then just the founders' agreements, all those agreements that we talked about earlier, you're going to really have to bring into bear some of those things: governance issues, minority protection issues, all the confidentiality and all that kind of stuff that we talked about earlier is all going to come into play when you're taking in investment dollars. And something that that you have to be very, very careful about is you want to avoid what I call dumb money when you're taking in third-party in investors. You really want to look for people that will be investing in your company that are aligned with you on their outlook for the company, on their outlook for how they want the company to develop. You want to have an alignment with these people. You don't want to take in an investment from someone who has a terrible reputation for abusing founders and using whatever power that they have to take control of the companies that they invest in. So you really want to, try to investigate, just like the investor is investigating your company and you want to investigate who they are. What have they invested in before? How have they acted in connection with those other investments? And how can they help the company beyond just giving the company money right now? Do they know people in your industry? Can they make connections for you in your industry? Can they connect you to the next round of financing? These are all things that you have to think about. And you also have to think about whatever the terms of the investment that you set up, you have to make certain that the terms that these investors are demanding from you are not going to set you up for failure when you take in the next round of investment. They can't have, you don't want them to have so much control of your company through their investment that they are going to make it very difficult for you to negotiate a next round. Now, there's always going to be they're always going to have veto rights on your ability to take investors that are senior to them, or you can't just sell the company out from under them. Here's where, when you take in outside money, here's where those protected provisions become very important. And they're always going to demand them from you. But this is where the dumb, smart money comes. Since you're always going to be dealing with these kinds of restrictions when you take in third-party money, you need to be certain that the people that you're giving these tools to are the right kind of people. They've done this before. They know about venture investing. They know, how they have to step aside when the next round of financing comes in. They've demonstrated that they have stepped aside when the next round of financing comes in. Those are the kinds of people that you want to look for. You don't want to look for investment from someone who has never invested in a young company before, because their expectations of how this investment and how your company is going to grow and how your company is going to need to take in more investment over time could be totally at odds with how you think this has to work. And you do not want to come into conflict later on. And I've seen many, many scenarios in my time where someone took in money from someone that had never invested in venture before. They had no clue as to how these things work, and they were impediments to the growth of the company. And sometimes companies just fail, because if your company needs to take on additional investment, as most young companies will, if you've got the wrong partner who's invested and they have the tools to block things, that's just a recipe for disaster. So most important thing while you're negotiating an investment with a third party is know who that third party is, know what their reputation is, and know that they understand what they're getting into and know how to play in this particular sandbox. It's a different sandbox. Not everybody understands the rules of this sandbox, and you have to be very clear about that and very knowledgeable. Next slide, please. Okay. Here are some common pitfalls and mistakes. Trust but verify. That means put it in writing, right? If someone says, yeah, we're going to do all these things for you, and I want all these things from you because I'm going to be doing these things for you later on, put it in writing. Don't just, think that they're going to do what they say, because you would do what you said. Trust but verify, and the next one, get it in writing. Those two go together. The third rule that I have is it's never too early, and that gets back to it's never too early to create that limited liability entity to work through, to protect you from potential liability that you would have to shoulder as an individual if you're not working through a limited liability entity. The next rule is time is not your friend. they're really, and this is a really important thing to remember. You may be the first person to come up with this new idea for a new company. That does not mean that there's someone nipping at your heels, or who a year later or less than a year later may come up with the same idea. When you come up with that idea, you want to begin to run with it. You want to execute on that as well as you can and as rapidly as you can. Not running with the idea in such a way that you're missing all the fundamentals. You're building a crappy product. You're building a company on a poor foundation. I don't mean rush, but always understand that time is not your friend. You don't necessarily have time to waste when you're building your company. And certainly, the corollary is that when you are taking investment in from third parties, when let's say you've gotten to that point where you've developed a company to such an extent that now you're ready to take in third-party money, once you sign that term sheet, you do not want obstructions to arise between signing that term sheet and closing that deal. Right? If it begins to take too much time, you may lose the attention of that venture fund, or they may uncover something that you didn't even realize, because now they've got tons of time to sift around in the industry or sift around in your documentation. And they find something that now they want to have corrected, and it takes time to correct it. And then they lose interest, or they begin to think you're not the founding team that they thought you were because you're not able to execute on this closing. So what time is not your friend means is don't leave things to be dealt with later on. Deal with things as they arise and handle them, right? Don't leave it for later. Because you don't want something that you have to clear up from a diligence standpoint. You don't want, there was that employee that we never got a release from when that employee left us. And getting a release from employees who leave you is very important. And the investors say, you've got to get that release signed before we close this deal. Or you didn't get a proprietary rights agreement from that guy that built your IP for you 3 years ago. You've got to get an invention assignment agreement from that guy, or we're not investing. You need to deal with these things, get that release, get that invention assignment agreement when the need arises. Don't kick the can down the road waiting for the big deal to happen, and then you're going to deal with it, because time is not your friend. If you're dealing with it then, it will delay your deal and you may lose your deal over it. And finally, my favorite, surround yourself with the best advisors you can afford. I can't tell you how important that is, because I wouldn't presume to be able, as a lawyer, I wouldn't presume to be able to write the code for your company, and you shouldn't presume that you can do what a lawyer does for your company. And you therefore, just like you want to build the code as best as you can, and you want to surround yourself with the best coders that you can find to build a strong, robust code, you want to find the best advisors that you can find to help you build the best legal or financial foundation for your company that you can possibly find. Just like all coders are not created equal, all lawyers are not created equal, all accountants are not created equal, and really seek out the best that you can find, even if you're stretching yourself a little bit out on the cost curve beyond where you wanted to be necessarily. But it's all about building a firm structure for your company, and that is invaluable. And I think we're done. So thank you. I hope this has been helpful. This screen tells you who I am, and I welcome anyone that has viewed this webcast. If you have any questions about it, feel free to reach out to me. And if I can help you as you're forming your companies, by all means, please reach out. Thank you very much, everybody, and have a pleasant day.